this webinar debate focused on the very live topic of what happens after lockdown, or logdown, which is Theo Paphilis has been saying. We said at an early stage that the stay was welcome, but that it would lead to a tsunami of possession cases when it was lifted. I don't think we're going to be wrong about that. We're all going to be very busy in the future. What we wanted to look at, though, is what is the appropriate way to deal with things in terms of law change, etc. In the debate today, we are lucky enough to have a guest speaker in addition to members of Chambers. Laurie Macfarlane is an economist and writer based in Edinburgh. He's currently economics editor at the openDemocracy and a fellow at UCL Institute for Innovation and Public Purpose, New Economics Foundation and Democracy Collaborative. He's the co-author of the critically acclaimed book, Rethinking the Economics of Land and Housing. For those of you who are new to Zoom and haven't attended a webinar before, you will notice that our mics are muted. Your mics are muted and your videos off. This is a pre-setting, so please don't be alarmed. It just stops any background interference. Because this is a debate, we will be inviting contributions from you after the speakers have delivered a short address. So what we intend to do is to have each of the speakers speak, and then if you can indicate via the Q&A function, firstly, what your contribution may be, and secondly, whether you want to make your contribution live. If you don't want to make your contribution live, then please just do so on the Q&A function. But if you do indicate that you want to make your contribution live, then Rachel will identify you and reveal you to the world so that you can make your contribution to the debate. We are recording this session, so a copy will be available after you or any of your, if any of your colleagues are unable to attend. So Lindsay Johnson is going to go first with his spiel. I would want to add one thing, which is certainly Lindsay and other speakers are adopting a role. It isn't necessarily, or doesn't necessarily accord with their own views. The idea is to try and spark debate. So over to you, Lindsay.
Thanks, Jim. COVID-19 has impacted on all aspects of life, as we all know. Let's take Mary as an example. She's got a mortgage and the usual household bills. Her income stopped in March 2020 when the lockdown and associated measures came into place. She's now in arrears of her mortgage repayments. And while she's agreed a mortgage holiday with her lender, all that's doing is postponing the problem for a short period and shores up problems for the future. She's finding it hard to pay utility bills and to support her child. She's certainly somebody who engenders sympathy, until you realise that her income comes from a rental property. Her tenants both work, but they've been sporadic in paying the rent. And then we're in 1 month's worth of arrears at the start of lockdown. They're now in 3. Both tenants work, both have been furloughed and are only receiving 80% of their income. They've not paid any rent since lockdown started. So the question has to be, why should Mary risk losing her home because someone else can refuse to pay rent with no fear or recourse? Now, of course, it's not that simple. There's relief available to Mary from her mortgage lender and from the government in terms of delayed repayment of taxes. There's assistance available for her tenants. But none of that alters the fundamental principle that this is Mary's property. And when she entered into this contract, because the tenancy is just a contract, it was on the basis that the occupiers, if the occupiers didn't keep their side of the bargain, she'd get her property back from them with relative ease. She knew that, and the tenants knew that. Where then is either the imperative for change or the need for change? We need to test that theory. Let's take it a little further. The focus has always been on rent arrears, but that's not the only ground for possession. What of those who sublet potentially for property? What of those who commit acts of damage to a property they're renting? What of those who commit acts of antisocial behaviour? The current stay on eviction and the extension of time for notices covers all possession cases, including those where the ground has no relevance to coronavirus or its effects. No one commits ASB because of COVID-19. So if there is any basis for a change, it's one rooted in an economic argument based on rent arrears cases alone. So let's place that issue in context with some statistics. There's 4.5 million households in the UK living in the private rented sector. That's out of a total of 27.2 million households. They're predominantly younger, over half are between 25 and 44, and with the fastest growing sector being between 35 and 44. The majority, some 74%, are in work, or at least they were in work before the public health crisis started. An average of 32% of their income went on rent. Those figures depend on the income bracket into which you fall. So for the lowest income bracket, it's about 64% of your income that goes on rent. But that means that in what I've phrased as normal times, 50% of private rented sector tenants said paying the rent was easy. Only 5% were in arrears, according to the Office for National Statistics. And that's reflected in the homelessness statistics for the last quarter of 2019. Of the 67,000 people who were owed the relief duty, i.e. those who were homeless and eligible with no thoughts of intentionality or no thoughts of priority need, only 3,500 cited private sector rented arrears as the reason for their homelessness. Of course, the current crisis is going to alter those figures dramatically. There are going to be more people are going to be in arrears, more are going to be in unaffordable accommodation. But does that justify fundamentally ripping up the principles of not only landlord and tenant law, but of property ownership? Now, one solution that's been mooted is to extend the pre-action protocol for possession claims by social landlords to the private rented sector. Now, that protocol, as we all know, imposes an obligation to discuss the causes of arrears and the tenant's financial circumstances, and to agree affordable sums for the tenant to repay towards the arrears going forward, focused on the individual themselves, not by some arbitrary 2-year timescale. It assumes that proceedings will be adjourned or postponed if an agreement is made and if an agreement is kept to, and it imposes an opportunity to consider ADR. Now that's a proportionate way to deal with the problem that now presents itself. It creates a presumption that landlords will have to afford an opportunity to repay before eviction occurs, and puts the responsibility for paying rent where it should lie, on the tenant. Again, this was a contract. Now I concede that there is something needed to give any use of the pre-action protocol teeth. In that regard, you can see the proposals of the Housing and Local Government Committee that came out this morning that are both limited in scope and in time to afford a discretion to the courts to refuse possession even on ground 8 until the end of the year are to be welcomed. And it's that sort of proportionality that allows the country to return to normal, not attempting to radically alter centuries of law in a common law system at a time when the country needs to rebuild. Jim.
Thank you, Lindsay. If we can then move on to Martin's contribution, please. Muted.
Thank you, Jim. Thank you, Lindsay. I'm going to speak to the proposals that the Labour Party have recently put forward as a 5-point plan. And it's good to follow on from Lindsay, because there's some of what he says that has to be accepted, that what has to happen here is a balancing of a number of interests that play into this debate. There may be an occasion, and it may be a useful time to embark on a wider debate, but what we need at the moment are some measures to abate a crisis that we find ourselves in. And the proposals that have been put forward by Labour are in recognition of that, but that they recognise that they're not intended to solve the housing crisis. They recognise that in the longer term, we do need stronger regulation, and we do need to build much more affordable and social housing. But faced with the extraordinary circumstances that we are faced with now, we have to have a package of measures which achieves balance, which does produce temporary relief, and importantly is deliverable, because we do have to recognise the political circumstances in which we are living. And the proposals I put forward are ones that in many ways build on consensus that has already been achieved, in particular about Section 21 and mandatory grounds of possession, and seeks to develop a set of proposals that are likely to also command consensus. And they recognise that while a great many people are in great distress as a result of the consequences of coronavirus, not everybody is necessarily going to be suffering in the same way. So just to look at the part of the background to this, if I can move on the slides, which I don't think I'm going to be able to. Yeah, so just so far as the figures are concerned, there's about 11 million private sector renters, and the figures that have been recently put to the Housing and Local Government Committee, which Lindsay referred to, were that something like 1.7 million of them are likely to lose their jobs in the next 3 months, and 2.6 million of them are likely to be in rent arrears by the end of the period of the stay. And sadly, there's little end or little evidence of a clear end in sight. And so that really brings us to what the 5-point plan is. And it's intended, and you've got to bear in mind, this is a temporary measure which is intended to deal with the risk of a tsunami of claims that is likely to happen at the end of June or early July. And the first part is to extend that temporary ban, so extend the stay for 6 months or for as long as is needed to implement the changes that are going to be made. It's difficult to see that anyone can realistically disagree with that. Lindsay has referred to some of the other problems that arise, particularly if other grounds for possession have come into play. But the fact is that where urgent relief is needed, then you can get an injunction. And in an exceptional case, you can lift the stay. So again, the stay produces that kind of balance. Then give residential tenants the same protections as commercial tenants by protecting them from being made bankrupt. Again, it doesn't stop progress towards securing payment of arrears, but it does stop a landlord trying to achieve by the back door what they can't achieve through possession proceedings. Then bringing forward the proposals to scrap Section 21. I'll have a little bit more to say about that later on. And then the fourth and fifth points are that given that evictions are going to be presented, give renters at least 2 years to pay back any arrears accrued during the period. That's perhaps the most controversial part of the plan. And again, I'll come back to that. And then an essential part of the package as well is that the state has got to be prepared to step up and help where assistance is needed. And the Labour Party has called for improving provision of universal credit by lifting things like 2-child limit and speeding up payments, but also a temporary increase to local housing allowance to help prevent the risk of homelessness. Now, I just want to speak to a couple more of those just to see how they work. So far as the Renters Reform Bill is concerned, you're aware that the government currently proposes to abolish Section 21 evictions, but that's only going to operate for future tenancies, and it's going to be balanced by giving landlords more rights to recover possession of property. I get that from the Queen's speech. And so, although that's something that should be brought forward to give certainty, it's not going to help the people who are currently in arrears and are currently in difficulty. And that's why the proposals in the interim report of the Housing and Local Government Committee are welcome. What they propose is that there should be a temporary discretion for Ground 8 and Section 21, and that gets around the problem of making it all rely on the goodwill of landlords, as I think Lindsay conceded wouldn't be sufficient. And in deciding whether or not to grant possession, the court's got to consider the extent to which any rent arrears are the result of coronavirus. And that, I'd suggest, does strike the right sort of balance during the period that we're going to be moving into after the stay on possession proceedings has come to an end. The point that's caused perhaps some of the most, but then the local housing allowance, well, it's gone up to the 30th percentile already. What really needs to happen is that that's got to be a long-term measure. Although it's been talked about as going up to the 30th percentile, it's in fact restoring it because there was an earlier freeze. And in fact, it's restoring it, what it needs consideration to do is to restore it up to the 50% level that it used to be when it was first introduced, because it lags far behind real rents. And again, that's something that the committee has called for, and it's completely in line with the Labour Party's proposals, again, demonstrating the level of consensus around these measures. And then the final point, and really the controversial one, is the idea about paying rent arrears back in, or having 2 years to pay back rent arrears. And what one has to confront there are the many calls for saying, well, that doesn't go far enough. All it does is postpone the debt that has to be paid. And wouldn't it be better just to cancel those arrears during that period? Well, that I'm afraid is likely to be unrealistic, both in the public sector and in the private sector, because in the public sector and in the social rented sector, it simply takes away from those landlords the funds that they need to maintain the housing stock. And there's no real proposal as to how to deal with that. And in the private sector, again, we have to recognise that there are the kind of balances of interests that Lindsay's been talking about. Over half the sector is very small landlords who depend on rental income to a high degree. And it would be unbalanced to provide a complete stop on any obligation to pay during that period, quite apart from the legal difficulties it would raise under the ECHR and Article 1, Protocol 1, and the right to possession. So again, what's needed here is balance, time to pay, backed up by discretion in court.
Excellent, thank you, Martin. As I say, we're delighted to have Laurie with us all the way from Edinburgh, where they're still suffering full lockdown. They haven't had the ease of restrictions we've had, so Laurie hasn't been out for years. But anyway, I'm delighted he's able to speak to us now. Over to you, Laurie.
Great, thanks very much. And thanks very much for inviting me. It's a real pleasure to be able to take part in this event. I should just stress up front that I'm not a lawyer. My background is in economics, not law. But nonetheless, I think that the legal aspects of this debate are absolutely critical. So thanks again for having me, and look forward to hopefully even learning some new things myself here. In the time that I have, I'm going to talk a little bit about a recent paper, drawing on some of the things that we outlined in a recent paper that was done for the IPPR think tank. And the paper was called "Who Wins and Who Pays? Rentier Power and the COVID Crisis." And I should also say that what I'm about to say are mainly my own thoughts and don't necessarily reflect the views of IPPR. But I think a good starting point with this discussion is to kind of zoom out a little bit and recognise the scale of the economic crisis that we're facing here. According to the Bank of England, they predict that the economy will shrink about 14% this year. That'd be the deepest recession in more than 300 years. And that assumes that the lockdown sort of ends in June and things return to normal fairly quickly. So, of course, it could be a lot worse than this. Now, these kind of big, grand aggregate statistics don't necessarily mean much to many people. But in practice, what it means really is that someone, somewhere, will be forced to take significant financial hit as a result of this crisis. And the question really is, who should this be? Who should be, how should that pain be shared across different actors in the economy? Now, I think it's important as well to recognise that going into this crisis, obviously, people were coming in very, very different circumstances. There are people already in very precarious positions. And one of the main reasons for that is because of the UK's fundamentally broken housing market. We have for the growing numbers of people in the private rental market, the amount of income that is spent on that on average across Britain is about the mid 30% today, and that's up from 10% in 1980. And it's among the highest in Europe. It's much, much higher than this in places like London and South East, of course, where people can be spending over 50% of their incomes on that. We know that before this crisis, up to a third of private renters were already going into debt to pay their rent, and most of them have no savings. And England, I think, within the UK, remains a sort of outlier, quite extreme outlier in Europe in terms of both the high costs and the insecurity that tenants already face. So if we look at the question of, well, who's being asked to share who's being asked to take the burden of the crisis so far? We know that there's been nearly 8 million people furloughed under the job retention scheme, many of who have experienced a drop in income of 20%. Others, of course, haven't been so lucky. We've seen a wave of redundancies, nearly 2 million new people applying to universal credit, which in some cases will provide an income of just £94 a week. And of course, many, many businesses have been forced to close and have seen their revenues collapse completely. But renters, private renters, have been left particularly exposed. As we've already heard, there's been some changes to the local housing allowance, but this will still leave large shortfalls between what people are being asked to pay and their ability to pay it in terms of their income. And what's been quite striking about the government's approach so far is that it's assumed that landlords can be sort of trusted to show, I think they use the term show compassion, and tenants to tenants, and they can kind of negotiate with each other on a level playing field. And the government guidance at the moment states that when the crisis is over, landlords and tenants should work together to agree an affordable rent repayment plan, which is kind of oblivious to the significant power imbalances that exist between landlords and tenants. And although we've seen today that the government has announced that it's extending the mortgage holiday support for homeowners for another 3 months, as we've heard, the suspension on evictions is currently set to end on the 25th of June. And I think most of us would agree that unless some action is taken, we're looking at a sort of tidal wave of evictions and homelessness crisis looming if we don't do something about that. And we're also looking at saddling people with mountains of rent arrears, which they'll then have to pay back on top of their ongoing rent commitments. And so if you take a step back, when we look at the significant hardship that's being faced by many in the economy, the sort of protection of landlord income is quite striking. And rather being shared across society in a kind of fair and proportionate way, it's pretty clear that so far the economic risks and costs of the crisis are disproportionately being shouldered by those who are already in a financially vulnerable position. And that essentially what we're seeing is that those who are least able to weather the crisis are being asked to make the biggest sacrifices to basically protect the incomes of those who are, in many cases, most able to weather it. So we're seeing the government, we're seeing government provide income, and both in terms of grant and loan support to households and businesses, but that's basically to make sure that they can continue to make payments on things like rent and debt repayments, etc., so that these payments can continue to flow upwards. So what can be done to do this? Well, in the short term, as we've already heard, I think extending the ban on evictions is essential. And to that extent, I think what's in Labour's proposals is certainly welcome to avoid this catastrophic wave of evictions. But crucially, this doesn't do anything about this issue about who's taking the financial pain, because as we've already heard, Labour's basically said that people have 2 years to pay back the rent arrears during the crisis. But because this doesn't actually reduce the burden in the long term, landlords are still not really being asked to share any of the cost, the financial economic impact of this economic downturn. And given the scale of the crisis, when many businesses and households are taking significant hits, I think we need to ask the question, why should landlords, who, let's be blunt, have done better than almost any other group in the economy over the course of the past few decades, be unique among anyone in having their incomes basically fully protected, which is essentially what we're kind of seeing at the moment. And so in our view, in our report, we say that we think it's only fair that we recognise this situation, and that it is appropriate that landlords might be asked to share in some of the pain and take some form of a haircut, if you like, on rental income over a time period. Now, there are a number of different ways that this can be done. One the proposal that we mention in the report is a proposal to basically grant struggling private renters basically a suspension on rents without arrears accruing for a very specific time period, short time period, for example, 3 months, alongside the extending the eviction ban, for example. And at the same time, you could have an extension on mortgage holidays for mortgage landlords to make sure that they can also, that's addressing that cash flow issue there, that they're not still having to pay mortgages at the same time as not receiving rental income. And then for smaller landlords who genuinely rely on rental income and can demonstrate that that's the case, and indeed any banks that might face liquidity problems from mortgage payment deferrals, you could have targeted post hoc income support at the other end provided by government and the Bank of England. And so what this approach kind of does is, rather than the current approach, which basically tries to support the incomes of households to enable them continue to pay their rent in full, thereby basically protecting landlords' incomes, this would basically suspend these payments for a period of time and then support, in cases where there is hardship being felt by landlords, support that in a bespoke basis at the other end. Now, there have been some issues that have been raised around, I think was already mentioned, around Article 1, Protocol 1 of the European Convention of Human Rights. Obviously, I'm not a lawyer to wade into this, but have spoke to a number of lawyers who seem to think the issue is not necessarily as clear cut as it's been made out to be. But more broadly, I think, in my view, if our starting point is to accept that any policy which infringes on landlords' ability to extract rents at prevailing market rates is a violation of their human rights, then I fear that we're really going to have a very hard time making any headway on dealing with the housing crisis. Because, as I said, others have taken serious hits here. Why should landlords be entirely shielded from this? Now, none of this would be enough to address the sort of longer-term structural issues with our broken housing system. As I say, the problems that we're facing here are partly an outcome, a function of the fact that we've had such a dysfunctional housing market for such a long time. And so this doesn't solve that. But what it does, by suspending rents and evictions, it provides some essential breathing space for the many, many households that are facing quite extreme hardship at this time. And again, provide a bit of time also for policymakers to make a proper plan for tackling some of the more systemic issues that are responsible for leaving so many people in such precarious circumstances in the first place. I'll stop there. Thank you very much.
Great, thanks, Laurie. And thanks for introducing the term landlords getting a haircut. And on that note, we'll hear from Jamie, who probably needs a haircut.
Consequences of lockdown, as I haven't been anywhere near anybody with a pair of scissors in their hands, thankfully. That was incredibly impressive, if I may say so, from Laurie. I mean, I was struggling really to think what I can add to that. I'd sketched out a few slides under the proposition of radical enough, which of course was a question being asked of the positions that Lindsay very eloquently adopted on behalf of landlords. Couldn't detect any hint of him being disingenuous in those propositions, but we're faithfully told he is entirely disingenuous, doesn't believe in any of it. Martin, of course, as the voice of reason, is a ubiquitous fact. Martin sounds reasonable whatever he's proposing, and if he was making these proposals from a more radical perspective, I'm sure they'd be a lot more palatable than coming from me, particularly with this hair extension I'm currently exhibiting. But even leaving all that aside, what I was sort of planning to do was just to talk a little bit about how we could be more radical and the reasons why we perhaps ought to be more radical. And some of it overlaps with what Laurie's already said, so I'm just going to skip through that. But Lindsay, could you just move on my slides? Yeah, so the first, and if it isn't obvious enough, was just to make the point that, we should never allow a good crisis to go to waste. And a particularly interesting historical account, 2017, from Walter Schiedel suggested that you can't actually reliably reduce, or economic disparities have not been reliably reduced in the past, unless you've had things like plagues, revolutions, massive wars, or collapsed states. And if we are genuinely in the context of an unprecedented health crisis in the form of the COVID-19 pandemic, then this is an opportunity as good as any, and perhaps the best opportunity any of us will see in our lifetimes, to be frank. And reflecting that, the current political climate is a febrile one, and there's in my view, at least, a genuine sense that political opinion is really malleable. I mean, you've got things like guaranteed basic income, a proposal that 5 to 10 years ago was literally considered laughable, now getting mainstream traction as being a possible solution, or a one element of a solution to the economic crisis that Laurie just sketched out a moment ago, and in terms of trying to devise a kind of a new settlement, really, for people and their governments going forward. And so if those kind of ideas are already gaining political traction, what are the equivalent ideas in the context of the housing space that we need to be thinking about? Lindsay, could you? So, and just to repeat again, and this really does reflect something which Laurie has just said, these are old problems. The housing crisis, as it's been so described, has gone on now for decades. It's definitely one of affordability rather than supply. The basic acknowledged human rights standard is that people shouldn't be spending more than a third of their income on housing, otherwise they are constituted as being housing poor. And Lindsay's own slides showed that even from the landlord's perspective, pretty much everybody in the private rented sector is exceeding that 1/3, and indeed those on lower incomes are looking at something closer to 2/3. And again, something that won't surprise many of you that are listening, wealth inequalities in Britain remain pretty persistent, and I've given some facts there which are pretty stark in support of that. So, febrile political atmosphere, once in a lifetime opportunity, old problems, and two specific elements of those old problems, or symptoms, I should say, of those old problems are the first point made there: the poorest 10% of households had debts 3 times greater than their assets, so they are essentially completely insolvent as kind of economic entities, as it were. Whereas the rich 10% have amassed a wealth of 35 times larger than their total debt. So there it gives you some kind of stark indication of just how skewed the economic imbalance has become. And in terms of a policy symptom, we are currently spending 22 billion a year on housing benefits. So that's a direct cash transfer, essentially from the public sector or the state to landlords, albeit, of course, some of those are social landlords, but a huge number of them are private sector landlords. So that's private individuals benefiting from those steady income sources from the state. And I've given you there just a reflection of just how big that budget is. It dwarfs spending on the police, overseas aid, and the budgets of many entire government departments, and has doubled since the early 2000s. So there is a cash stream there that we might want to look at when it comes to potential solutions. I'm sorry, Lindsay, there you go, thanks. So shouldn't we just be cancelling these rent arrears and preventing any COVID-19 evictions at all? And again, I think Laurie's pretty much made that case. And the principal difference between the moderate position adopted by Labour and articulated by Martin, which is simply suspending the obligation to pay these rents to one that cancels paying them, seems to me to be reflect in a more honest way the scale of the crisis that people are facing. And simply delaying their obligations to pay these rents to a future date simply ramps up the debt obligations on people already, as I've just shown in the previous slide, labouring under very extensive debt. Just on that point, I mean, inbuilt into the moderate position, as far as I understand it, is 2 things. One, that the courts themselves will be able to evaluate whether or not rent arrears are in actual fact COVID-19 related. In other words, that factual assessment is something that the moderate position would require the courts to undertake in any event. And I think that's probably a sensible position. I mean, what our courts can be trusted to do is to reach a reliable finding on the facts as to whether or not there is a cause and effect between 2 events. Indeed, you can't think of a better institution within our current society to carry out that task. However, the second part of the moderate solution is much more problematic in my view. It's just this discretion, this sense that somehow the courts are the ones best able to judge whether or not it's right or wrong that somebody should be evicted in the context of having COVID-19 rent arrears. And to me, that is clearly deeply problematic for all sorts of reasons. But ultimately, it shouldn't be up to our judges to make those incredibly complex value judgments. And what we'll actually see in practice, of course, is that landlords will operate according to their own fundamental political instincts. And I think that is deeply dangerous when you're looking at a problem of this scale. And we all know, working in this area, how variable those political instincts can be. And should it therefore be up to individual judges to be making those decisions? And is it right that individual tenants are left to the mercy of whichever particular judge they get on a particular occasion? It seems to me much better that that decision should be made in a centralised way as part of an overall plan to tackle the problems that are arising because of COVID-19. And the sensible solution is to cancel those rent arrears. And then Laurie described some other mechanisms that could be put in place to compensate some landlords where it was appropriate, for example, where individuals are dependent on their rental income to maintain their own property and avoid evictions in their own lives. And then I think going into the longer term, we should be giving landlords a choice between having their properties taken back under state control or submitting to rent controls, which prevent the type of inequities that have been so rampant in the housing market and have led to a situation where people in the lower income bands in the private rental market paying 67% of their income on the housing costs, and homeowners are only paying on average 18%, which demonstrates the level of inequity that we're looking at. And then we've got that 22 billion of housing benefit that's being transferred from the state to the private rented sector, and in particular landlords, to landlords and in particular the private rented sector every year. And we could be using some of that income, some of that asset to compensate landlords where it's necessary to do so according to A1P1. But in return, we get an asset that the state owns that we can then use for a social purpose. Social housing, one might decide to call it. So I think there are real reasons to take a much more radical approach to this problem. This is once in a lifetime. And if we're going to come up with radical solutions, we need to have the confidence to say that they're the right solutions. And if we, as lawyers acting in this sector, cannot join forces with economists like Laurie working in this sector to make that type of call, then nobody else is going to do it. Thank you.
Excellent. Well, we were hoping that we'd have some contributions from the floor now in terms of either points they wanted to make or questions they wanted to ask, with the intention of this being a live debate. But I see that there are no questions at the moment. I don't know if I was unclear as to how these questions should be put. If you'd like to, oh, somebody said something. If you'd like to make a point, either in writing or in person, then please let us know on the Q&A, and then we can ask Rachel to reveal you to ask your question. I don't know if Simon Mullings wanted to make a point, and whether we could reveal Simon in order to make that point.
Let me unmute him one sec.
Thank you. Is he there? We might get to see his guitars and stuff again.
Simon, you should now be able to speak. I think we're muting and unmuting each other.
Are you there, Simon? Can you hear me, Mother? Nope.
How's that?
Perfect.
We can hear you.
Yeah. Hi, everybody. Hello. Hello.
Hello.
Fascinating talks from all four of you, and I don't know about anybody else. I swung one way and then the other. Perhaps not so much towards Lindsay, although I would have done, I'm sure, were he expressing his own views. But absolutely fascinating. I just wonder if I can raise very quickly some just very local and immediate stuff about the aftermath of PD 51, which was that the courts are now being asked to make plans for when PD 51Z is lifted. There are various reports coming in from around the country, some of which are under embargo to talk about, some of which are not. But in London, we know that the London courts
have issued a consultation, a very, very quick consultation with response dates of various days next week. Now, each London court is doing this individually, but the text of the consultation is the same for each. And it includes possession lists starting up from the 29th of June, all remotely, so by telephone or video where possible, and all without any housing possession duty scheme, which is the major concern. Well, there's a huge amount of concerns about all of it, but the proposal to do it without the duty scheme is a major concern to me as a duty advisor. If you're in an area served, if you're working in an area served by one of these courts, then probably you or your firm will have received an email about this consultation. So I won't go into the detail, but just to let you know that very shortly, by the end of the day, I hope on the Housing Law Practitioners Association website, that's HLPA, HLPA. .org.uk, you will find, if you wish to take it up, a standard response to that consultation, just for the London courts, but it's a standard response to their points, which we've drafted very quickly. We believe it reflects HLPA members' views, and it very much reflects the evidence that we put together in the Arkin versus Marshall case, which I'm sure you're all aware of. So that will be on the website. If you want to cut and paste it and send it by email, then you'll know the email address of your local court. You're more than welcome to do that. If you want to adapt it, that's also fine. If you want to make it more hard-hitting, if you want to make it less hard-hitting, whatever you want to do. If you do adapt it, please don't attribute it to HLPA though. But if you copy and paste it, by all means attribute it to HLPA if you wish. Just very briefly then, the main problem with the consultation is about the lack of court duty. And we had a meeting with the MOJ, the days all drift into one, but I think it was yesterday. And we asked them about this. And the head of civil and family legal aid policy, but within the MOJ, was absolutely categorical that there's no part of MOJ thinking to start possession lists without a duty advice scheme. And so we do think that this is a little bit of an adventure that's being had. So we would urge you, if you can, go to the HLPA website, and if you want to respond, please do. Sorry, I've talked too much. There you go.
No, I think that those are all really relevant points, and it's all obviously a changing picture. I must admit, when I saw that letter, I was immediately concerned about people just arriving at court, whether virtually or not, without any representation, and probably at that point only identifying that they need representation. And you know what will happen in that situation. It seems like the letter said that in the case of vulnerable tenants, the court would be willing to adjourn or something, but it seems to me that it's a lot of these possession cases are going to go through on the nod, which is a real concern, I think. Anyway, we have some contributions. There is...
Just on that, Jim, though, I mean, on the duty solicitor point, somebody has just made a point in the chat to... which something that struck me. Why couldn't you have a duty advisor just sat in the call? I mean, there'd be no opportunity for advance to take instructions in advance, but given that it's just an exercise in acting almost as an amicus curiae, you could do that quite easily by having somebody who's just sat in the call.
Yeah.
I can't, I mean, that, given that you have to get, if you accept you have to get possession lists moving, not necessarily for possession, but for other things, then why wouldn't that work as an extreme measure for a period of time?
Do you want to come back on that, Simon, if you're still around?
He's gone, but...
He's gone.
I'll bring him back, one sec.
Bring him back.
Simon, where are you?
I mean, somebody on the chat just made the obvious point that they need to see the documents. They're worried about even getting people on the phone. I mean, they're valid points. And
fair point, yeah.
But if what you're saying is we're concerned about this because of if someone is saying my arrears accrued because of coronavirus, it seems to me you don't need to see any papers to know that. It just becomes essentially some sort of plea of mitigation, doesn't it? And saying, well, therefore you shouldn't grant possession, you should adjourn it. Yeah. Particularly if the draft bill goes through.
It's Vicky Fuchs. Did you want to speak, Vicky, as well? Well, let's hear from Simon anyway, if you want to.
Am I here? Yeah.
Yeah.
Okay. So it's a good idea. The trouble is, first of all, the housing possession duty contract specifies that the advice must be face to face. I'm sure that could be got around. I'm sure there was a will, then even the legal aid agency might just move on that point. But the consultation document itself also makes clear that the judge may not be in court and probably actually won't be in court. And that last minute papers won't get to them for that very reason. And so I'm not sure actually having the duty advisor sat in the court is going to actually help at all. One of the things that a duty advisor does is distill everything down into a very small but perfectly formed knot of information for a judge that is hopefully palatable to them. And so actually getting these hearings through, even in the half an hour that they propose to allot for a telephone hearing, is just not going to happen without the assistance of a duty advisor, in my view.
Okay. We had an anonymous attendee who made a point fairly early on that says, what does the panel think about the viability of making the universal credit housing benefit backdate provision more generous in order to help deal with COVID-related rent arrears? It wouldn't be a complete rent arrears waiver, but would help prevent evictions and give some relief to renters. Any views?
Well, in some ways, it's in keeping with the recommendations that the Labour Party are making in their 5-point plan. And in one sense, I suppose it may not matter much whether you, in terms of the overall sum, whether you do it by backdating, whether you're more generous about payments going forward. If it's going to be a long-term solution, then it may be that the past arrears can be dealt with by giving appropriate time to pay in any order, and that I think is going to come on to one of the next comments we've got. And what will really matter will be the security of being able to meet the payments going forward, and for that you are going to need to have a much bigger increase in LHA amounts as a much more long-term proposition, because part of the difficulty that has been created is that people are losing work where they've been in accommodation which has been significantly above current LHA levels, and then something's got to be done to meet that gap going forward. Maybe that's a greater obstacle than clearing arrears in a lump sum from backdated payments.
Did you want to say something about that, Laurie?
Yeah, I was just going to say briefly that obviously, the increasing, there's various different versions of this, whether it's sort of increasing local housing allowance further, or various different forms of public support to help people pay rent. And again, I just think to stress that that still doesn't address the issue which was kind of talking about, which is that's basically still giving more public money into the pockets of landlords to ensure that they can receive their rent in full. And bearing in mind, this is on top of the significant amounts of money that we're already giving to landlords, as has been highlighted through housing benefit. Obviously, a significant proportion of the amount of money that we're paying out in the furlough scheme at the moment is going towards landlords as well. And so I think that I don't disagree with the sort of longer term aim or medium term aim of making our benefit system more generous in relation to housing. But I think that has to be coupled with measures that make housing more affordable. You know, whether it's rent controls coming out of this crisis or other things, it needs to be coupled with something else, so that it's not just simply another case of the state, pumping more money in order for landlords to pocket, essentially.
Okay, so we've got a comment from Frank McGuinness. Have the panel any views on reviving an old concept within land law still recognised in Scotland and some agricultural cases of greater hardship rather than reasonableness? That concept would create the possibility for Lambeth versus Henry style orders for 20-year-odd repayment plans in the private rented sector. If the terms of those repayment orders were free of interest, that would effectively transfer the nature of the burden of outstanding rent arrears. Might that constitute the sort of radical reformulation of housing law that some panelists were suggesting? Who wants to take that?
But just, again, were these to be my views, I wouldn't be at Doughton Street. But play devil's advocate. Why on earth should you be able to repay rent or repay a sum due under a contract over a period of 20 years when the contract required it to be paid by a set date? Why should the state interfere in the privity of contract between the landlord and the tenant, particularly after the event of the creation of the contract? It just doesn't make any sense at all. I mean, it doesn't just impact on on landlord and tenant issues. It impacts on contract law in general, doesn't it? I can't see why it doesn't.
I mean,
that seems to me to be the problem with it.
Can I follow from that, Jim?
Of course, yeah.
I mean, it just seems to me that the starting premise for this whole discussion is that there's got to be some interference with the private law rights of landlords vis-a-vis their tenants. That's where this debate ought to begin rather than where it should end. And why I think Frank's suggestion is an interesting one is that I think it strikes an interesting middle ground, but as Laurie says in relation to the housing benefit solution, it doesn't really tackle the underlying issue about who should ultimately take the hit. It sort of tries to almost ignore the issue by delaying it into the long grass by giving such nominal repayments that tenants can presumably afford it, and landlords can presumably cope with not getting the debts repaid for that long. And neither of those propositions may ultimately be true. And also it ties a landlord and a tenant together indefinitely, whereas in fact, the private rented sector, if it serves any social goods, is it allows a relatively high churn, which may have some other advantageous economic consequences. But more to the point, it seems to me it's an example of where the common law might ultimately try to step in to solve a social problem that is being played out in front of it. And that's not really the solution that we need here. More than anything else, we need a democratic solution that comes through Parliament, which says that it genuinely is a problem of this magnitude and needs to be matched with solutions that are well thought through and are part of a coherent response. And that's where it seems to me that we should be in the territory taking out that element of discretion away from the courts. It's too much of a political burden for the courts to carry out, and it doesn't produce satisfactory results. We need to cross the nettle and try to resolve this through our democratic processes.
It's interesting because Pinky and Perky suddenly came on the line there, Jamie. I don't know what happened, but because you froze, and then I don't know if your kids got involved or is some sort of sabotage going on in your house. No, you've frozen.
No, can I while Jamie may come unfreeze, in which case he can join in and complete what he's saying. But I mean, Lindsay was presenting this as being an assault on fundamental property rights, but actually it may not be that out of step with fairly conventional methods which we've got. And so, for example, you can have payment orders already, as the questioner makes clear. Similar models apply in consumer credit arrangements. There's similar provisions for administration orders and things like that. And what this might allow is to square the particular circle that the problem with the Labour proposal, the response the Labour Party gives to the why don't we just forgive the debts altogether, is, well, not everyone needs that relief. And why cause all that? I don't know how far that is an overstated point, but if you had this kind of discretionary model, which, although it does just postpone it, the reality is it does shift the burden to the landlord in that case, and they might as well have the arrears written off. But you can then do it on a case-by-case basis in cases where it's really needed, without the need to interfere with contract law generally.
That's sort of the point that Laurie objected to, isn't it? Because that would require it to be administered by the judiciary. And Laurie's point was, well, why should a judge be the person who decides this? Which then feeds into what Jamie was saying about how you need a democratic solution, whatever that means. But I don't really follow the logic of that, because yes, the system we have how is that different to what we have at the moment? Because at the moment you have a system whereby you're in arrears, you go to court and you say, I can't pay it, can I have some time to pay it? Now there has to be a limit on the amount of time you repay it over, but the judge can still make a Lambeth Henry order now. There's no to stop them doing it. There's no statutory bar on it. And it might be that is something that emerges as a way of dealing with it. But I don't see why that would necessarily have to be the default position. It seems to me that what that argument leads you to is leave things exactly as they are at the moment, because you can leave it to what we're all always told is the good sense of county court judges. I mean, we can all say that we don't believe that, and we all have examples of why we don't believe that. But that could be an answer to this entire problem.
Do you want to come back on that, Laurie? No. Okay, so let's go on to the next one, which is a comment from Philip Sace. He's playing the devil's advocate here. He says social housing have a clear and structured process that sometimes leads to the possibility of a cat and mouse game with regard to collaborative working to reduce rent arrears. Would the panel think that to impose this on a contract between parties in the private rented sector is too onerous, especially for the small provider? That's the first question. Is the social housing sector equipped and adequately resourced in assisting those especially vulnerable with housing arrears? And does a conflict of interest arise from the social landlord giving it additional support and guidance when they are guiding tenants in prioritising their financial resources? Any views?
Sorry, Jim. Can you hear me now? I've lost video because I can't retain the bandwidth. Sorry. Can you hear me?
We can hear you. Did you hear the contribution that I just read out?
Yeah, I did. I mean, I was just going to make the perhaps rather obvious point that it feeds into the point that Laurie was making, that again, even in the context of social landlords, it's not appropriate to see the solution to this problem as being one that can be meted out by the compassion shown by even social landlords. It's too arbitrary, and it's too big a problem for them to grasp, it seems to me. There is an obvious conflict of interest. I mean, we've all seen it in the numerous cases that we've done ourselves, where you've got a tenant who's vulnerable, supposed to be getting some support that's in some way connected to the housing provider. They say they're not getting the support they need, and in the meantime, the housing provider is taking them to court for possession. So it seems to me, again, that's indicative of why this solution needs to come from a different place. And just to clarify what I meant by a democratic solution, Lindsay, I meant one that comes through Parliament rather than one that comes through the courts.
Okay. So I just wanted to, Vicky's raised a very good point, which is we won't know anything about the benefit situation, etc. This is the duty advisors. It's the work that's done outside of the courtroom that would be totally lost. I think that's absolutely right. But also, I did want to say that in response to the kind of male dominance point that you've raised, Vicky, it's interesting because we really tried, because we were really sort of conscious of the fact that we're basically middle-aged men. Sorry, Laurie, you're probably not, but and we were trying to kind of get some women involved, and we did honestly try and do that, but we didn't manage to get there. So anyway, I'll move on swiftly before I get my coat. So Alice Irvin says, thanks for this very interesting panel. I'm aware that the New Economics Foundation have a paper on suspending rent and how that might be implemented. One suggestion they make is that there should be legislation stipulating that for the relevant period, non-payment of rent would not constitute a breach of contract. Do you have any thoughts about how a more radical approach should be implemented, framed in legislation?
It's always struck me that one of the simplest ways to do this is to fix a period of time between, say, the 1st of April and whenever this finishes. So say, for the purposes of argument, the 1st of July. And just have a piece of legislation that says any rent that falls due within that period is not rent lawfully due for the purposes of establishing a ground of possession. There you go, you solved the entire problem. So you can't rely on it to obtain possession, yet it's still a debt. You couple that with some modification to the insolvency legislation, which prevents you from being declared bankrupt as a consequence of it, and it's problem resolved.
Anyone else want to say something about that?
Problem avoided.
Can't hear you, Jamie.
I was just saying, I think that is more consistent with the problem being avoided rather than necessarily solved. I mean, if Laurie's analysis is right, and I appreciate that none of us are economists to challenge it, then it's perhaps not enough to continue people's debts, even if you come up with some clever mechanism which in theory prevents those debts from ever being called in or any consequences following from them not being paid. At the end of the day, if the situation is such that these people are not responsible for the debts that have arisen because some external event has caused them to be unable to pay their rent, then it's up to the state to come up with a solution which reflects that, rather than a kind of sticking plaster which doesn't do anybody any good.
Okay. So a quick bollocking for you from Craig in Birmingham, Lindsay. It says, the role of the advisors to assist the defendant. You need to speak to them and look at the paperwork in order to establish whether they have a defence to the claim. Our role is not simply to make pleas in mitigation. Lindsay.
Yes, can I just repeat for the 4th time? If I genuinely had the views that I am expounding today, I wouldn't be at Doughty Street. And I agree that the role is more than a plea in mitigation. I think my point was this. These are extraordinary times. And if you accept that this government is going to reinstate possession in some form at a time when you still have remote hearings, with all the difficulties that presents, then you have to think of some way of protecting their property rights that they have in their own name. And the one way I can think of doing that is to have dialed into the call at all times a qualified lawyer who is a specialist in housing law, who, if the individual isn't represented, can remind the judge what the legal position is and advocate on their behalf insofar as they are able, having heard what their evidence is and what their situation is. I thoroughly accept it's not adequate. I thoroughly accept it's not ideal. But if we're going to go down this path, you have to have some way of protecting people's rights and interests. And that was just the one way of thinking about it.